The last of these canons that we'll look at in this lecture is the whole act rule. So the whole act rule is a canon that says, in general, you want to interpret each section of a statute in the context of the whole enactment. And the presumption is that there's some kind of statutory coherence, that the whole statute hangs together and makes sense. Now notice that the whole act rule applies to a single particular enactment, right? So let's say, the Clean Air Act, and the Clean Air Act has, hundreds of different sections, and they're very complicated. And so the presumption would be that what Congress is trying to do is something that hangs together and makes sense. So, if this part of the Clean Air Act says, all smokestacks must have air scrubbers, and this part of the Clean Air Act says only some smokestacks have to have air scrubbers, and it seems like those two things are in conflict, a court applying this whole act rule is going to try to find a way to read those things so that they aren't in conflict, because the presumption is they work together somehow in the act. Maybe this is an exception or different kind of smokestack, who knows. You should note, however, that the titles of an act are generally not used to determine statutory meaning. It's assumed that the titles are not part of the actual legal enactment. They're just there for convenience. Preambular and purpose clauses, generally courts will say, are entitled to no greater weight than any other part of the statute. They're entitled to some weight, but nothing beyond the specific weight. And then we've looked already a little bit about this rule against superfluity, or we can say also a rule against redundancy. Every word or phrase is presumed to add something to the statutory command. Another aspect of this is the use of similar or identical words in different parts of the same act. And so the presumption is that the same meaning applies to the word every time it's used within the same act, or sometimes even looking at related statutes, as we'll see in a moment. And if there's a variation in the terminology, that variation suggests some kind of reason for the variation. So again, let's say a clean air statute in one part says that air scrubbers shall be used on smokestacks, and then in another part says on smokestacks over 50 feet air cleaners will be used. Well, what's the difference between an air scrubber and an air cleaner? It could be that there's really no difference and it's just sort of a little bit sloppy. But applying this canon, a court's going to try to look for a reason because there's a change in the wording. The non-derogation rule says that one provision should not be interpreted to derogate from other provisions, so that, and this will come back to that clean air example again, if the statute says all smokestacks shall use air scrubbers, and then another provision says smokestacks shall not be required to use air scrubbers, we're going to see there what we call an operational conflict. And it seems like, how do you comply? Do you have to use the air scrubber, or do you not have to use the air scrubber? A court will often try, if it can, to figure out a way to sort of rationalize that and make it fit together. Again, maybe this is an exception, maybe this applies to different kinds of smokestacks, whatever it might be. There are other ways in which there can be tension within a statute. There could be philosophical tension. The overall purpose of the statute is really to make the air cleaner, so why would you not have scrubbers? Or structurally, pieces of the statute don't fit together. The overall point is when you see that kind of inconsistency within a particular statute, a court very well might apply this canon and try to interpret it in ways that make the inconsistency go away. Now again, if you're a textualist, that might only go so far, and there might be, you might more quickly get to a point where you say, if this is a mess, it's a mess that the legislature has to fix. If you're more of a purposivist, you might say, well, I as the court can interpret this in a way that sort of keeps it together. If the legislature still doesn't like what I did, the legislature can still change it. But I'm not going to allow something that just doesn't make sense to kind of stand. So that's the difference in the philosophical tension. So let's see how this all plays out in a case, which is West Virginia v. Casey. So this is another fee-shifting case. So notice that the statute here, in certain kinds of civil rights cases, says that the prevailing party is entitled to a reasonable attorney's fee as part of the costs. Now, if you think about it a little bit, the drafting of this is really confusing because generally we think about, well, costs are one piece of things that you might get to recover and that are actually fairly routine. But attorney's fees, it's relatively unusual because the American rule doesn't ordinarily, without a statute allowing it, let you recover attorney's fees. So it's a little odd that it puts fees and costs together. Now there's another federal statute that lists categories of costs, and that statute includes witness fees, and the witness fees are set at $30 per day. So you can see the idea is, well, you might have to make a witness come to the hearing, and they lose some time. You're going to compensate their time, and that's what it allows. But the issue in this case is whether the petitioner is allowed to recover $100,000 in consulting expert fees. So this is a litigation that involves a state challenging certain regulations about Medicare costs, and they've got economic experts and so on, and they're trying to recoup those expert fees. So Justice Scalia writes the majority opinion, and one of the reasons this opinion from Scalia is here in the book, as you might see from the notes, is the book. I think the book's authors like to illustrate Scalia as a textualist, but they also like to point out places in which they think Scalia is perhaps departing from his expressed textualist views and maybe doing other things, and that might be what's happening in this case. So Scalia looks to not only the particular statute at issue, but looks to other parts of the U.S. Code and says, Scalia says, when I look at other parts of the U.S. Code, there are plenty of places where Congress has provided for expert fees, expert witness fees and consulting expert fees. And when Congress does that, it's explicit. So for example, the Toxic Substances Act says the cost of suit and reasonable fees for attorneys and expert witnesses are covered. The Equal Access to Justice Act says reasonable expenses of expert witnesses, reasonable costs of a study, analysis, engineering report, or test, and so on. So it specifically recovers consulting expert fees in addition to attorney's fees. And so Justice Scalia says, when I look at these other parts of the U.S. Code, it shows beyond question, he says, that what Congress does when it wants to give consulting expert fees, it does that explicitly. And if I don't say that, then what I'm going to end up doing, if I apply this statute as broadly as the petitioners want, what I'm going to end up doing is making all of those statutes superfluous, all the language in those statutes, because there's really no need for it. All you have to say is, fees and costs, and that would include consulting expert fees. Why would you have to specify it in all of these other statutes? And Scalia says that the purpose of the statute includes not only what it sets out to change, but also what it resolves to leave alone. And the best evidence of what the statute wants to change or leave alone is the actual text. So notice this really sort of kind of clever sort of judo move in his textualism. The background presumption looking at the whole of the U.S. Code is that, and looking at the American rule, is that you don't recover these kinds of fees. The presumption looking at the whole code is when Congress wants to include it, it does so with specific language, and Congress didn't do that here. And so therefore, Scalia says, these consulting expert witness fees are not compensable under this statute. Now again, here's a case where you notice you've got a dissent. You've got Justice Stevens and Marshall and Blackmun, so you've got a liberal bloc dissenting. And Stevens says, well, no, when I look at costs, it has a broader meaning than it might in other contexts, and in particular, he looks at legislative history, right? So here again, you see Justice Scalia is going to dismiss this legislative history. Stevens is going to say, when I try to understand the purpose of this, the legislative history says pretty clearly that this is a field that's designed to a statute that's designed to level the playing field, and in particular, it's designed to allow individuals to act as a private attorney general. What's a private attorney general? Well, think about it. There are lots of kind of regulatory statutes that are enforceable by the government, by a state attorney general or the U.S. Attorney's Office, and there are fines and penalties that might get imposed. The government only has limited resources and limited time and can't pursue all of these cases. So a typical thing in this kind of regulatory scheme is to provide for a private cause of action, which gives an incentive to individual litigants to go ahead and enforce the statute in cases in which the government might not be able to step in. But of course, the individual litigant also has to undertake litigation costs. So how do you limit those litigation costs, and how do you incentivize, in a relatively kind of small case, a person to bring the claim and an attorney to represent the person? You have a fee shifting. And that's what a private attorney general kind of statute is. And Stevens says, this is what this statute's all about. In fact, he says, there was an existing Supreme Court case, the Alaska Pipeline case, and the legislative history makes clear, and that case limited the costs that could be recovered in these kinds of actions. And the change to the statute was to make clear that it was not overruling, but modifying the rule in Alaska Pipeline. By the way, we'll see a little bit later in the semester when can and how can Congress respond to a Supreme Court opinion. Because of the separation of powers, Congress cannot overrule the Supreme Court. But there are instances in which the Supreme Court interprets a statute, and then Congress is able to, and it's not a constitutional rule announced by the Supreme Court, so Congress isn't overruling the Supreme Court. It's just saying, okay, you've interpreted it this way, now we're going to write it differently because this is what we really mean. And so Stevens says this is what Congress was doing in this case, and we should look at that legislative history. Stevens kind of pokes back at textualism here, right? The court shouldn't put on thick grammarian spectacles and ignore evidence of congressional intent. And this just shows how kind of some of these canons, whole act rule and other canons like that, may play out different ways depending on kind of what your philosophical approach to interpreting legislation is. Now, the notes kind of give us an interesting bit of history in terms of what happened after this case. So notice that Casey is decided, and then just 8 months after that, and think about it in today's climate. Of course, it was a different climate, but Congress to do anything in 8 months is pretty extraordinary. So 8 months after, Congress says, no, this is what we meant. We want this kind of thing to be covered. So query, what does that mean? Does that mean Stevens was right, and we shouldn't be too picky about interpreting statutes because it's inefficient and it goes back to Congress? Or is Scalia right? Scalia might say, well, okay, fine. I mean, that's what Congress wants. That's what Congress can do. The court played a valuable role in interpreting it and in showing Congress, look, if this is what you want to do, you need to be more clear about saying it. And that at the end of the day, 8 months later, and after a lot of litigation and so on, we have a clearer statute. Okay, so I'm just going to leave you with this now. The whole act rule, and to the extent there is a kind of whole code rule, presumes that what Congress is doing is a relatively coherent process, and that there's a rationale to it, there's an overarching rationale, and it's going to produce some kind of meaningful result that fits together. It's a presumption. And as the notes suggest, and as any observer would I'm sure agree, that presumption isn't very realistic. I mean, legislation is not made in a really neat linear fashion. It's filled with compromises. It's filled with pieces that indicate lobbying and all that sort of thing. And this brings you to the old quote that you've probably heard, which is comparing legislation and sausages, right? If you like, this is Otto von Bismarck, if you like laws and sausages, you should never watch either one being made. And the idea here is, there's lots of sort of gross stuff that goes into a sausage, and it all gets kind of ground up together. And you don't necessarily want to see that if you actually want to enjoy the end product. And the notion here is with legislation, same thing. A lot of stuff that gets put in there and ground up. So maybe it makes sense, nevertheless, to just have this kind of artificial presumption that says, no, the end product has to be presumed to have some coherence to it. Otherwise, we're we're going to be lost in a kind of morass of trying to figure out what compromises were made or were not made, or not. So I'm going to leave you with a little video actually of some sausage being made, just so you can kind of visualize, what this quote is sort of saying in relation to legislation. So I'll let that little video play out, and then I will see you in class next week.